Hear ye, hear ye. I'm Chief Justice and Justice of the Supreme Court of the State of Michigan. All persons having business with this honorable court are admonished to draw nigh and give attention, for the court is now sitting in special session. God save the United States, the State of Michigan, and this honorable court. Welcome. It's not often we have a crowd this large for our administrative proceedings, but welcome to the January and first of our administrative proceedings. We have just one item noticed today for consideration at the public hearing, and it is a proposed amendment of our Pro Hoc Vice rule, which is the rule that is permits lawyers not licensed in the state to temporarily practice in the court. And we have one endorsed speaker, Mr. Kerschel.
Good morning, Your Honors. May it please the Court. Alan Kerschel, Grievance Administrator on behalf of the Grievance Commission, and I'd like to spend a few moments making some comments in support of the rule changes. By way of brief background, after this Court appointed me to this position back in October of 2014.
Are you still happy about that?
I am, Your Honor. It wasn't a trick question.
Yes, it was.
I am, thank you. I had undertaken to look at the various functions of the office and learned that we were very much involved in the Pro Hoc Vice process. It struck me at the time that it was not consistent with our core mission, which is the protection of the public. I also learned that we were devoting a fair amount of resources to this process. We would receive approximately 700 applications a year. It's been pretty consistent since about 2008. We would field questions from the attorneys. We would contact the lawyers. And on the average, a member of my staff was spending close to 2 hours a day processing these applications. I contend that the current rule will streamline and improve the process. Promptness is important because, as this Court well knows, these applications come in at a point in time typically when a matter is pending before a court. Currently, the current rule, the Michigan sponsor must send the various application materials to the Attorney Grievance Commission. We are then required to notify the court concerning whether or not the applicant has practiced in Michigan, and if so, how many times within the past year. The State Bar currently has the function of collecting and accounting for the fees. It's essentially a bifurcated and inefficient system that we currently have. The proposed rule that we have submitted is the result of cooperation and collaboration between the Attorney Grievance Commission and the State Bar. We've had a series of terrific meetings to work on this proposal, and we contend that transferring the process from the AGC to the State Bar will certainly improve the process. The rule as proposed will now require the applicant and the sponsoring attorney to submit materials instead of to the Grievance Commission, to the State Bar. And the State Bar would take over the processing of that. Also, a product of the proposed rule change will be to improve and streamline the process in the sense that there will be electronic filing requirements as it concerns the filing of the motion certificate, of the fees, the confirmation of payment, notification to the court that the attorney has been granted permission to appear in a Michigan court in the past year.
Is the State Bar ready to go live with the electronic system?
Excuse me, Your Honor?
Is the State Bar ready to go live with the electronic system?
Perhaps that question is better left for the State Bar, but I believe as to this process, they certainly are. I should add that currently...
Excuse me, Ann, do you know the answer to that question?
So, yes, I talked to the State Bar when this was pending. The way that the rule would normally go into effect is May 1st if it's adopted. They said the May 1st date would be perfect for them in terms of implementation. So they're not ready to go live today, but they would be...
So they're not going to start in a paper process and then transition. We're going to wait until they're ready with their new electronic system?
The rule remains, the current rule remains in effect until May 1st. Okay.
I guess as a follow-up, since we're addressing to Ann, Mr. Gershell said the Attorney Grievance Commission answers phone calls as sort of almost like a help desk function, customer service function. Will the State Bar be taking over that function as well?
That's my understanding.
Okay.
You want to add to the question also, while the system will be an improvement, is that we receive currently almost half of the applications in paper form. So this now requirement that it be electronically filed will be a huge improvement to the efficiency of the process.
A couple of things. One, until you mentioned it, when we first embarked on this is something I kind of brought to the court because we had no process for it. And I attended a conference where I heard how other states had handled the Pro Hoc Vice issue. We had no idea how many were occurring in the state. The fact that there are some 800 is kind of an interesting fact. I also find it interesting that when we made the change from having the AGC make notifications as opposed to the court making the notifications, the number of notifications went down, which is probably not because there were fewer applications, just the courts were not very effective in transmitting the notice.
I think that's probably correct. Because as I indicated, the number of applications have been pretty consistent and even predates the changeover in the rule, I think, which was in 2011. Certainly, if there is an issue with respect to the conduct of the temporarily admitted attorney, the process provides that if we receive a request for investigation, we will then take back that case and we'll look at and we'll investigate that as we would any other allegation of misconduct.
To your knowledge, have there ever been occasions for discipline of lawyers admitted pro hoc vice?
When I looked at that issue, in 2015, we only received 2 requests. So, and as far as one of those matters have never panned out. So it's really a de minimis number, but certainly if it happens, we will do what we're supposed to do.
Anything else, sir?
I just wanted to say that, thank the court. I think that this rule will certainly be a huge improvement. Thank you for your time.
Thank you for your time. Thank you for your comments. There being no other comments, the public hearing is adjourned.